As you enter the court, you're sort of going from one atmosphere into another, almost a sort of different planetary system, and it's one which is hostile to human life. You do not feel comfortable, content, welcome there. You feel you're in an alien environment where you need oxygen in order to breathe. And that's by design. It's meant to intimidate. It's meant to make you feel small. It's meant to make you feel that you're up against the crushing weight of an enormous system. And indeed you are.
Over the past 3 years, I have spent countless hours following the twists and turns of the legal case known as Hibbert versus Hall. Although I have no legal training, I am now very familiar with the details of the case, having taken a keen interest from the start. And so I've decided to put together this basic guide to explain what it's about and the implications this landmark ruling has for investigative journalism and freedom of speech. A word about my interest in the case. The defendant, Richard D. Hall, runs a website called Rich Planet TV. I first discovered this site in 2018 and watched all the episodes about the Manchester Arena incident as they were released. But a High Court injunction issued in November 2024 forced the defendant to remove all of these episodes from Rich Planet TV, along with all other Manchester-related material, including the Hibbert v Hall trial transcripts, for which he'd paid several thousands of pounds in transcription fees. This archive of material was vital for anyone wanting to gain a full understanding of the case. Luckily, many of these documents, including the trial transcripts and judgments I'll be referring to in this video, were uploaded to an assortment of other websites at the time they were made available, and so I have collected together the links to these documents and archived them for anyone to read and download. I strongly urge you to do this. My Manchester Arena Incident Resource page is available here at pighui.substack.com and also at pighui.co.uk. The Hibbert v Hall case is a particularly sensitive one, with most people siding strongly with either the claimants or the defendant. But I hope you can put your feelings to one side and look at the facts revealed during the trial and the legal precedents set by the judgments. Before I go through the details of the case, I'll just give you a quick summary of the very basics. The claim number was this: KB 2023 002 102. It was a civil case and it was heard at the High Court of Justice in London. So this wasn't a criminal case where there's guilty and not guilty, it was a civil case where there are judgments handed down. The claimants are father and daughter Martin and Eve Hibbert. Martin and Eve are two of the reported victims of the Manchester Arena incident, which took place in the foyer of the arena on the 22nd of May 2017. The defendant is Richard D. Hall, and there were two precedents set by the case which I'll go into in detail later.
A BBC investigation has revealed how conspiracy theorists are spreading falsehoods about UK terror attacks and tracking down survivors to their homes and workplaces to see if they are lying about their injuries. One survivor of the Manchester Arena bombing is preparing legal action against a man who says he spied on victims. The investigation was for BBC Panorama and a Radio 4 podcast by disinformation and social media correspondent Mariana Spring.
I think it's fair to say that most of the awareness of the Hibbert v Hall case in the wider public comes from the media's pre-trial coverage surrounding the defendant's surveillance of the claimant Eve Hibbert. At the main trial, the facts about what actually happened regarding this were established, and I'll go into that later, but it's the judgment in favour of the claimant Martin Hibbert that shapes the harassment by publication precedent set by this case. The emotive reporting surrounding Eve Hibbert has overshadowed this important aspect of the case. The media circus was set in motion by the BBC in late 2022 when an extensive and coordinated strategy involving peak time news reports, a TV panorama special, prominent online articles, and frequent trailers for the 10-part radio podcast series entitled Disaster Trolls. The inevitable tabloid headlines followed in its wake. But it was the BBC at the vanguard, and evidence suggests that their commitment to this particular story ran deeper than the surface-level conspiratainment served up to the masses by Mariana Spring. In his summary of evidence, Richard D. Hall presented a timeline of the BBC's involvement in the case, and I've picked out a few of the events which stand out to me. On the 7th of October 2022, the defendant was visited at his place of work by 3 BBC journalists, including Mariana Spring, who filmed him after he had previously told the BBC that he did not wish to be filmed. And this was the starting pistol on the run of programmes depicting Richard D. Hall as a, quote, disaster denier and a, quote, disaster troll. And this in turn preceded the legal action against him. On the 25th of October 2022, the BBC contacted YouTube to complain about the defendant's YouTube channel, which resulted in the removal of the channel, even though the channel did not contain any videos about the Manchester Arena incident. On the 1st of November 2022, the BBC contacted Merthyr Tydfil Borough Council to complain about the defendant's market stall, resulting in the council's decision to terminate the stall. But most important of all, on the 31st of March 2023, Richard received an email from Mariana Spring of the BBC in which she stated that Hudgell solicitors had informed her about submitting a legal claim against him. And yet Richard himself didn't receive formal notice of a claim until May 2023. And so this must mean that the Hibbert solicitor, Hudgells, were in communication with the BBC over a month before the defendant in the case had received formal notice of legal action being taken against him. And so, in my view, this is evidence of the BBC's weighty influence playing a role behind the scenes. There's much more to be said about this, but I'm going to move on because I have a lot of ground to cover. Okay, so I'm going to take you through these documents now. I'm going to go through this at a rate of knots. Every single one of these documents, there's a lot in them, and I'm just going to pick out some very brief details from each one. You really need to download and read these documents for yourself if you want to get a handle on this case. And that's especially true if your sympathies lie with the claimants, because you might read these documents very differently from the way I read them. And so I'm starting with the particulars of claim. This was the first document to be submitted to the court, and it was submitted on the 17th of April 2023 by the claimants, who are Martin and Eve Hibbert. Eve Hibbert was represented by her mother, who's called Sarah Gilbard. The claimants seek damages, an injunction and other remedies against the defendant under the Protection from Harassment Act 1997, the Data Protection Act 2018, and in misuse of private information, and the claimant's claims are based upon conduct by the defendant, including publications by him related to the claimant's status as victims of the bombing of Manchester Arena in May 2017. The particulars of claim ran to 14 pages, And reading through it, the thing that struck me was that there didn't seem to be all that much in there about harassment of the claimants. Most of it seemed to be taken up with details of the work of Richard D. Hall and the programmes that he published on Rich Planet TV. This struck me as rather odd at the time. Going on to the defence, this document ran to 21 pages and was submitted in June 2023. Here is my summary of the key plank of the defence. Following his extensive investigation into the incident, the defendant concluded that he found no evidence that a blast from a large TATP shrapnel bomb occurred in the city room that night. And that was put forward in the defence document with this, quote, "The defendant avers that the incident involved a pyrotechnic type device, or at most a low-impact bang, and as such no death or serious injury was caused to any person present or who was nearby." The defence document summarises with this, quote, "The claimants are seeking to bring a claim against the defendant for being an independent broadcaster who has advanced opinions which are different from the narratives presented in the mainstream television and print media about this incident, all under the purported guise of alleged harassment to them personally. This therefore amounts to censorship, or rather an attempt at it, via the High Court of Justice. Accordingly, the claim is denied as an abuse of process of the court and should be struck out." So that put the legal wheels in motion, and from what I understand, the next step would be that if the parties didn't come to an out-of-court settlement, a date would be set for the trial. But the Hibbert v Hall case didn't pan out that way, and here's what happened. On the 9th of November 2023, the claimants applied for what's known as a summary judgment. What is a summary judgment? It's a legal procedure where the court can decide a claim or a specific issue in a case without going to a full trial. It is used when the court is satisfied that one party has no real prospect of succeeding in their claim or defence. The burden of proof lies on the party seeking summary judgment to show that the opposing party's case has no real chance of success. And so in the Hibbert v Hall case, it was the claimants who put in the request for a summary judgment, and the burden of proof lay with them. But once they had adduced credible evidence in support of the application, the defendant comes under an evidential burden to prove some real prospect of success or other reason for having a trial on these issues. And so what happened next was that a court date of the 29th of January 2024 was set for a summary judgment hearing. The case was heard by Master Richard Davison. The claimants were represented by Mr. Jonathan Price, who's their barrister, and the defendant was a litigant in person. First to make his case at the hearing was Jonathan Price, who was counsel for the claimants. This was a bit of a blink and you miss it moment, but it's really crucial to understanding what happened at the summary judgment hearing. He put forward the argument that the criminal conviction of Salman Abedi's brother, who's called Hashim Abedi, satisfies the, quote, burden of proof requirement that the defendant's case would have no chance of success at a full trial. As a result, the evidential burden switched to the defendant to persuade the judge that his defence had some real prospect of success at a full trial. And so the lion's share of the time of the summary judgment hearing went to Richard D. Hall for him to make his case. And so the summary judgment was handed down on the 8th of February 2024 by Master Richard Davison. He found in the claimant's favour. You can read this judgment for yourself. It runs to 12 pages, but I've just picked out a few paragraphs here to show you the flavour of it. With regard to the evidence surrounding Hashim Abedi, the summary judgment concludes that Hashim Abedi was convicted of 22 counts of murder in respect of the bombing. His conviction followed a 6-week trial at the Central Criminal Court, which concluded on the 17th of March 2020. Abedi's conviction is a, quote, weighty piece of evidence in its own right. It falls to the defendant to prove the contrary, which is a burden I find he has no real prospect of discharging. I do not propose to engage with the detail of the defendant's evidence. Suffice it to say that although his beliefs may be genuinely held, his theory that the Manchester bombing was an operation staged by government agencies in which no one was genuinely killed or injured is absurd and fantastical, and it provides no basis to rebut the conviction. If summary determination of the issues is unavailable, the defendant will use the trial as a vehicle to advance and test his, quote, staged attack hypothesis. This intention is plainly evident from his witness statement. At many points in that statement, he calls for further investigation and inquiry. And so the final conclusion of the judgment was this, quote, for these reasons, I find that the defendant has not discharged the evidential burden which rests on him. He has no real prospect, indeed no prospect at all, of success on the issues, and I will resolve them in the claimant's favour. And so what happened next was that Master Davidson gave the defendant permission to request an appeal, and the request was considered by 2 further High Court judges. Ultimately, the request was denied, and so that was the end of the road for the summary judgment. The first judge to consider the request for appeal was Justice Karen Stein. This is one document that I haven't been able to track down, but I did manage to get a quote from it, which is, in my judgment, there is no real prospect of an appeal court concluding that Master Davison's reasons were inadequate or that his conclusions were wrong. But Karen Stein allowed the defendant a second bite of the cherry. He could request permission to appeal from a second judge. And so on the 21st of June 2024, there was a hearing before Justice Julian Knowles. This hearing wasn't held at the High Court, it was held remotely by video link. And on the 28th of June 2024, Justice Julian Knowles handed down his judgment. Now, I have been able to track down this document, and it makes for interesting reading. Here's a quote to give you a flavour of it. In all, the appellant's, which is Richard D. Hall's, evidence does not come close to establishing any sort of case whatsoever. The suggestion that third-party disclosure might yield something which would lead to the conclusion that the bombing was all a hoax can be dismissed out of hand as beyond far-fetched. And so the summary judgment at this stage was settled in favour of the claimants. And that is very significant because it sets a precedent for future cases. And so as I understand it, the upshot of this is that the summary judgment is now enshrined in case law. But it's Dr. David Hughes who understands the significance of the summary judgment. Quote, Hall's contention that there is no credible primary empirical evidence of a massive TATP shrapnel bomb having gone off in the city room was not allowed to play any role in his defence. The official version of events was the only permissible version of events. Going back to the Hibbert v Hall case, it looks to me like the claimant's legal team really had their ducks in a row right at the start of this case. The focus so far has been on the defendant, and he's been allowed a lot of time to present the findings of his investigation into the Manchester Arena incident. and this has led directly to the summary judgment. And so it seems to me that getting this summary judgment was an important part of the entire process. And so finally we get on to the main Hibbert v Hall trial. It took place in July 2024 over 4 days from the 22nd to the 25th of July. Hibbert and others are listed as the claimants, and Mr. Hall is listed as respondent. The trial was heard by Justice Karen Stein. Mr. Jonathan Price was counsel for the claimant, and Mr. Paul Oakley was counsel for Richard D. Hall, who in this case is called the respondent. As I mentioned earlier, I don't have any legal training, so I don't really understand why Richard D. Hall is listed here just as Mr. Hall, and why he's now a respondent rather than a defendant. The whole hearing transcript is available, and there's a link to it on my Manchester Arena Incident Resource page. It's 454 pages long, which is over 127,000 words. And I'm not actually going to quote any of this because you can look through it yourself, and I suggest you do. I know it's a very long document, but it's very readable. There's an awful lot in there that's of interest. To me, it reads like the script of a courtroom drama. The approved judgment was handed down by Justice Stein on the 22nd of October 2022. Richard D. Hall is back to being referred to as the defendant, a minor detail but one that stands out to me. Most of this 64-page judgment is taken up with the harassment claim, which unsurprisingly was settled in favour of both Martin and Eve Hibbert. The overall tone of the Stein judgment is excoriating. The censure heaped upon the defendant is relentless. But within the text, many important details about the defendant's actions were established and now form part of the written record of the High Court of Justice. I've done my best to distill these details for you here, but you will need to read the document to judge for yourself whether I have accurately characterised the Stein judgment. I'll start with this direct quote from the judgment, which was paragraph 14. The defendant denies the claim. In short, he contends that what may or may not have occurred at the Manchester Arena on the 22nd of May 2017 is a matter of significant public interest, and it was lawful and reasonable for him to publish his opinions. He went to Eve's home only once for the purpose of his investigation as a journalist. He never published the video footage he took from a public street, and he deleted it after he had viewed it. And so with regard to Eve Hibbert, the defendant made just one visit to Eve's home address on or about the 1st of September 2019. He knocked on the door several times, but there was no reply. And this is another direct quote from the judgment. Mr. Hall intended to try to speak to Miss Gilbard, who's Eve's mother. He said, and I accept, that he intended to ask if she would be interested in helping him by answering some questions about the Manchester incident, or words to that effect, and that he had no intention of speaking to Eve. I accept that his intention was to ask politely for Miss Gilbard's help. Justice Stein goes on to say, Mr. Hall then left his vehicle for a few hours parked in the street about 3 doors down from Miss Gilbard's house. On the dashboard he left the camera rolling. I accept his evidence that he placed the camera on the dashboard rather than hidden in a flower pot. The camera recorded footage which Mr. Hall later viewed. Mr. Hall subsequently deleted the footage from the memory card. He did not publish any of the camera footage that he obtained. And moving on to the harassment claim with regard to Martin Hibbert, I've written an overview of what was accepted at the High Court of Justice. Richard D. Hull had not met, contacted or tried to contact Martin Hibbert. Martin Hibbert's harassment claim rested entirely on the contents of the book and videos published by the defendant, and so this was a case of harassment by publication. Martin Hibbert has made dozens of high-profile media appearances and interviews on screen, in print and online, in which he has freely recounted his experience of the Manchester Arena incident, and all of the material about Martin Hibbert was gathered by the defendant from such public domain sources. But Justice Steyn didn't accept that. She says in the judgment, the defendant has objected that he has published information that was in the public domain, and he asserts that his opinions do not constitute the claimant's personal data. These objections are not sound. The definition of personal data does not incorporate any requirement that the data was confidential, and a statement of opinion can be personal data. And so Justice Steyn ruled in favour of the claimants, and this was a landmark ruling, and here's why. The defendant was earning a living as an independent journalist and broadcaster, and that's an important detail because, as Justice Steyn says herself in the judgment, no claim of harassment against a media organisation has succeeded at trial. And so, as I understand it, this Hibbert v Hall case, which was all about the Manchester Arena incident, has set a case law precedent regarding future harassment claims against journalists and other media-related defendants. And this judgment already seems to have had a chilling effect on some independent media organisations. So, after the judgment in favour of the claimants, Justice Steyn imposed an injunction and costs on the defendant. With regard to the injunction, the details of the injunction have not been made available to the public, and Richard D. Hull has made a very brief comment on its contents. Quote, "If I make public certain honestly held evidence-based opinions, I could face a prison sentence without access to a jury." And alongside this, he's had to take down all his videos regarding his investigation into the Manchester Arena incident from his own website. With regard to damages and costs, Justice Steyn imposed the following: £45,000 awarded in damages to the claimants, so that's £22,500 each. 90% of the claimant's legal costs, which amounted to £234,000. And that is on top of the £25,200 that the defendant had already been ordered to pay to the claimant's solicitor in March 2024 following the summary judgment. And so I make that a total of £304,000. Now, this sum is way beyond the means of the average UK worker, and Justice Steyn would have known that when she made the decision. And another important point to make in this case is that the defendant had no recourse to free legal advice or representation at any stage. He could not fund his own defence, but he was able to raise a substantial sum from well-wishers and supporters. And details of how this was spent are available on his website, which is richplanet.net. And so this sum of over £300,000 was on top of the money he had to find for his own defence. And so, following the main trial and the Steyn judgment, Richard D. Hull decided he would try to appeal the judgment. He set the process going in December 2024, but it was quite a while later before he put an update on his website. On the 9th of May 2025, he let people know that the appeal had been submitted on the 23rd of March 2025 and that the case was referred to a judge on the 2nd of May 2025 and that he was then waiting to hear from the Court of Appeal. Now, as I understand it, the appeal wasn't automatically guaranteed. He had to request permission from a High Court judge to have the appeal heard. And by now, there are no prizes for guessing what the outcome was. And it was actually Martin Hibbert in a post on X who broke the news on the 27th of May 2025. And so he writes, "Great start to the week. Richard D. Hull's attempt to appeal has been refused. Decision number 1. Permission to appeal is refused. The application is totally without merit. Number 2. Application for stay refused. Right Honourable Lord Justice Stuart Smith says, in my judgment, these grounds are no more than an attempt to achieve another airing of the defendant's theories. There is no substance in any of them. The judgment of Stain J is thorough, fair, cogent and compelling. An appeal would have no real prospect of success, and there is no other compelling reason for an appeal to be heard." And so Justice Stuart Smith became the 4th High Court judge to have a say in the Hibbert v Hall trial, alongside Master Richard Davison, Justice Julian Knowles, and of course Justice Karen Stain. With the latest refusal for permission to appeal, that means that the 2 landmark judgments now stand, and both requests for permission to appeal were turned down. And what happened next on Martin Hibbert's X account was really rather strange. I wasn't sure whether or not to include this, but I thought I'd put it in because it does seem relevant to the whole trial business. So this started on the 15th of June 2025 with a cartoon featuring Richard D. Hall in a missing poster, Have You Seen This Man? And so the gist of it is that Martin Hibbert seems to want Richard D. Hall to comment on the judgment. Now, it's clear from his previous X message that Martin Hibbert's legal team had made him fully aware of the outcome of the appeal. So quite why he wanted Richard D. Hall to comment on it seems a bit strange, and it got even more peculiar. From June the 18th on, every single day a new cartoon featuring Richard D. Hall was posted to Martin Hibbert's X account. So the first one was this, and in each one he's wondering what's happened to Richard D. Hall. So this one is maybe he's been abducted by aliens. Maybe he's been eaten alive by the Loch Ness Monster, and so on. Every single day for 51 days a new cartoon came out featuring Richard D. Hall and a new caption with a little quip about what could have happened to him. Now this is clearly an awful lot of work. Even with the help of an AI image generator, you still have to think up an idea and think of a caption to go with it, and then make the cartoon and put it out. And so you have to ask the question, was it really Martin Hibbert making these cartoons? Now, I don't know for sure the answer to that. And looking through them, it strikes me that it's difficult to know who the target audience is. Richard D. Hull himself likely never even saw any of these because he's not on X or any other social media, and there are very few likes and comments on any of them, so to be so persistent day after day putting these out when they're getting so little attention seems a little odd. And the other thing about them is that they really are quite goading. And so, for instance, this one has the caption, "Maybe Richard has been buried alive under £300,000 of demand letters." And yet, at the trial, Martin Hibbert said that he was absolutely terrified of Richard D. Hall and his supporters. He was scared of being physically attacked by either Richard D. Hall or one of his supporters. And in this one, it's clear that Martin Hibbert hadn't received any damages by this stage, because he's saying maybe Richard is going to surprise me on my birthday. And here's another goading one. Maybe Richard is getting used to life without bricks and mortar. Maybe Richard knows he is now finished for good and has left the building. And there's one here featuring Richard D. Hall, and I think the other person sitting next to him is supposed to be Ian Davis. Maybe Richard has taken up a new hobby. Lots of lame jokes about aliens and alien abduction. And this is the final one. Maybe Richard will be back with a cheque for me and Eve. And this was on August the 6th. And there were no more after this. And the reason for it is that there was an update on Rich Planet TV. And so in August 2025, a series of updates appeared on Rich Planet TV. There were two main aspects to the updates, and so I decided to deal with these separately. So first of all, I'll go through the bankruptcy proceedings initiated against Richard. Now this is really quite involved, but it starts with a quote from Richard D. Hall. He says, "On the 16th of July 2025, the claimant solicitors served a statutory demand which seeks a court hearing to make me bankrupt, which could then result in the selling of my house and removal of assets." And so I've done quite a lot of reading around UK bankruptcy law to get to grips with these various terms. But first of all, I should explain that in the UK, if someone owns their own home, that is usually their biggest asset. And in the case of bankruptcy, as Richard says here, that asset can be seized. But there is quite an involved procedure to bankruptcy and a lot of steps along the way. And so I've put together this very basic guide. So the first thing that Richard said was that a statutory demand had been issued by the claimant's solicitor on the 16th of July 2025. And a statutory demand is a formal written notice demanding repayment before a creditor petitions for bankruptcy, and it plays a critical role as a last legal warning in the bankruptcy debt recovery process. Going back to Rich Planet TV, the update said that a date of the 18th of August 2025 was set at Merthyr Tydfil Law Court for a directions court hearing. But in the end, this was changed and it was held in private online. So what is a directions court hearing? Well, it's a procedural court hearing where the judge or the district judge gives directions or instructions about how the bankruptcy petition and related proceedings should be managed. And so this sounds like an administrative thing, but it would also have given Richard the opportunity to ask for the statutory demand to be set aside. In an update put out on the 29th of August 2025, Richard said that the online hearing which occurred on the 18th of August 2025, which we were led to believe in emails and letters was a directions hearing, turned out to be the full hearing. As such, we had not submitted any evidence to the court. At the hearing, the judge ruled against me and ordered that, number 1, the application to set aside the statutory demand is dismissed, and number 2, the bankruptcy petition may be issued forthwith. Going back to these definition of terms, a bankruptcy petition is a formal application to the court to declare someone bankrupt. The bankruptcy petition is typically the last formal step before a bankruptcy order is made in the UK. And so, as far as I know, and today's date is the 3rd of October 2025, a bankruptcy petition hasn't yet been issued, but it is the next step in the process. And once that happens, the next step is a bankruptcy order, and that's when an individual is declared legally bankrupt. And if it gets that far to the bankruptcy order and you own your own home, the legal title transfers to the bankruptcy trustee, who will decide if the house should be sold to pay creditors. And that applies if you only own one home and it's in which you and your family live. And so we get on to the very latest updates from Richard D. Hall. He says that with all domestic remedies to get justice having been exhausted, he now has the right to appeal to the European Court of Human Rights in Strasbourg, whose role is to ensure that states are upholding human rights standards, and it does so by reviewing decisions of domestic courts in cases where a human right has allegedly been violated. And he goes on to say, quote, "In my case, I believe the judgment was a clear violation of ECHR Article 10, the right to freedom of expression, and Article 6, the right to a fair trial." He had 4 months to submit the application, and that was from the 27th of May 2025. So I make that the 27th of September 2025. Now, there hasn't been an update on this, so it's not been confirmed that the application was submitted, but I'm guessing that it was because he instructed his legal team to produce the written application in July. And that is the Hibbert v Hall trial story so far. All eyes on the European Court of Human Rights. Thank you for staying with me this far. It has taken a lot of time for me to unravel the complexities of the Hibbert v Hall case, and this is really just the bare bones, but I hope I have represented it fairly and accurately. Looking back, for me there are two standout aspects to the case which bear repeating. The first was the summary judgment hearing before Master Davison, in which the evidential burden of proof was swiftly discharged from the claimants to fall on the defendant, who was representing himself as litigant in person. Despite the defendant presenting extensive primary evidence from credible sources of the Manchester incident, Master Davison refused to, quote, engage with the detail of the defendant's evidence, dismissing his defence as, quote, absurd and fantastical. This has set a precedent for future cases. If a future claim for harassment is made in similar circumstances, the judge can refuse to engage with the detail of the defendant's evidence if he deems it absurd and fantastical, and rule against the defendant by summary judgment. That said, by allowing Richard D. Hall time in court to make his case, Much material and evidence from his investigation into the Manchester Arena incident is now on record in the Hibbert v Hull documents of the High Court of Justice. Was that an intended consequence of the legal action taken against him, or was it a miscalculation? And secondly, the precedent set by the Steyn judgment. Richard D. Hull earned his living as an independent journalist and broadcaster, and previous to this judgment, quote, no claim of harassment against a media organisation had succeeded at trial. Furthermore, Justice Steyn accepted the defendant's defence that he hadn't been aware that his actions had amounted to harassment. And so the harassment claim rested on the requirement that the defendant, quote, ought to have known that his course of conduct would have a harassing effect on the claimants. A reasonable person in possession of the same information that the defendant had would know the course of conduct in which he engaged would alarm, distress, and have a harassing effect on the claimants. And so the bar for a successful harassment claim against a journalist or media organisation has been reset from unattainably high to unmissably low by the Hibbert v Hull judgment. From now on, a harassment case may hinge upon the views of a hypothetical, quote, reasonable person about whether published material could have a, quote, harassing effect on a claimant. It can't have escaped many people's notice that here in the UK, social media is replete with phone footage of local cops turning up unexpectedly at people's homes, sometimes in the dead of night, to quiz or arrest or search the home of a hapless resident whose social media post had been reported to the authorities for having a harassing effect on someone. The mushrooming of such instances over the past few months has become a prominent talking point, and although this may not be as a result of the Hibbert v Hull judgment, I can't help but wonder if there is some connection. But it's an ill wind that blows no one any good, and several prominent free speech organisations have benefited from increased media attention and online reach, leading to increased revenue and membership. Widespread infringement of ECHR Article 10, right to freedom of expression, is becoming a very real issue in the UK, and I can only hope that the UK's free speech organisations will pay close attention to Richard D. Hull's appeal to the European Court of Human Rights. Thank you for watching.